Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by Nichole Labott, the Managing Director at SageView Advisory Group, to discuss recent pension legislation and retirement plan legislation. How are you doing today, Nichole?
I'm doing great, Brydon. Hope you are.
Doing fine. Thank you for coming back on the Benefits Companion.
Feel honored to be here.
I think most people, when they look back on 2020, will remember that year as the year of significant retirement plan legislation. Don't you think that's what when people remember 2020, it's going to be all about the pension legislation that went through Congress?
Maybe a little thing called COVID happened last year too, but definitely for us industry nerds, yeah, it was the year. I can't remember another time in my career where we had so much legislation to share with plan sponsors.
I know. I mean, at the beginning of 2020, when all we knew that there was some virus out there that we might have to be concerned about, my focus, and I'm sure your focus, was the Secure Act. The Secure Act was officially enacted on January 1, 2020, and made a lot of significant changes. I mean, kind of generational changes for qualified retirement plans. I mean, some of the changes included, increasing the automatic enrollment cap for safe harbor 401k plans from 10% to 15%, allowing a new in-service penalty-free withdrawal in the case of the birth or adoption of a child. New disclosure requirements. Congress is really concerned about the fact that we've moved from a defined benefit system to more of a defined contribution system. And so there was a new disclosure requirement in the Secure Act to require plans provide disclosure of the lifetime income value of a participant's 401k plan account balance. There was the increase in the required beginning date age from, it had always been 70 and a half, and that was moved to age 72. And then another change that we've been talking to our clients about is the fact that employees who work more than 500 hours for 3 consecutive years must be allowed to at least make elective deferrals into their 401k plan, which means employers need to be tracking that this year. That wouldn't, it's 3, and you count out 3 years, they have to start keeping track of those hours this year so they know whether they're going to have to allow part-time employees to start contributing to their 401k plan. So, Nichole, what do you think was of these Secure Act changes, what do you think were the most significant, and what was Congress, what was some of the motivation behind these changes back last year?
I would say, as it relates to the Secure Act, the one that I think more of my plan sponsors, committee members were honed in on was that required minimum distribution age. And that might just because I'm getting older and my friends and family are doing more planning. But I think raising that from 70 and a half to 72 definitely got most of the conversation. There was so much in Secure that we really felt was coming. All of it positive. I can't think of anything. Usually when we get new legislation, it sometimes some of it makes sense, some of it doesn't make sense, some of it's hard to navigate, but this was really straightforward. And I think that while for example, most record keepers are already disclosing the account balances on a monthly basis, the lifetime income disclosure requirement came, and I think everybody can conform with that and it'd be a good thing. So all in all, really positive.
Yeah, I felt the same way. The changes really made sense, and a lot of record keepers are already providing the lifetime income numbers. Of course, they're using their own assumptions and arriving at those numbers. But most plans, you can go online to your account and you'll see a projected lifetime income or monthly income that the amount that you have saved would result in, and that's really important for employees and plan participants to understand, to know where they are as they approach retirement. And so now with the new disclosure requirement, that's going to be more of a uniform that the Department of Labor is going to tell us the assumptions to use for those disclosures. But yeah, I can't remember a year where there was so much action, legislative action with regard to retirement plans. And as we were learning and getting clients up to speed on the Secure Act, the COVID pandemic occurred. And then in response to the COVID pandemic, we had more legislation. We had the CARES Act. How did your clients respond to the CARES Act relief for retirement plans last year?
I think everybody was completely in a reactive mode, including us. I can remember, us quickly convening with our team, how do we communicate this as soon as possible to plan sponsors so that they can weigh the things that are most meaningful for their employees? Because as you can imagine, across industries and plan sponsors, there was all sorts of different speculation about how this would impact their employees. And so that was kind of like almost like a trauma situation, if there is one in our industry. Yeah. Meanwhile, each of the record keepers were handling the CARES Act provisions differently. So some, the plan sponsor needed to opt in on. Some were assumed you were going to take them all unless you tell them otherwise. So navigating that was actually challenging and fun, and forced us to get up to speed really quickly on all the details. Across the board, most of our clients did elect to put forward all the flexibility that the CARES Act allowed for their employees. And I'm really excited to say that, despite the fact that the gates were widened as far as I've ever seen in terms of possible, distributions or leakage from retirement plans, what we saw across, at least our client base is only a few, and those who really needed it did request like a coronavirus related distribution or lengthen the time that they can repay their loan. So that was good to see. There were a couple of industries where, for example, the airline industry was impacted more greatly, and we saw larger distributions there. But all in all, I think we've navigated it well. And so I think it's a great time to really focus for those folks that did take a distribution, how and when they can possibly repay that distribution to themselves.
Right. And we won't get into detail now, but that concept of the CARES Act coronavirus related distribution in the Consolidated Appropriations Act, more legislation that was passed is still in 2020. It was right at the wire at the end of 2020. There's the new qualifying disaster distribution that's apart from the coronavirus related distribution, but now there's this disaster related distribution concept going forward for future disasters. And then there's more legislation on the horizon, what many people are calling Secure Act 2.0. They're legislative proposals, and these include mandating that all 401k and 403b plans provide for automatic enrollment, enhancing catch-up contributions for participants who are age 60 to allow them to make a catch-up contribution of $10,000. Again, increasing the required beginning date age. Now it's 72, increasing it to age 75. Really interestingly, treating student loan repayments as though they are elective deferrals under a plan that can be matched. So an employer could be making matching contributions to an employee who isn't actually deferring under the plan, but is paying off student loans. So that, there's such student loan debt out there that would be really helpful for employees who have student loans. The Secure Act requires, as we discussed, participants or employees who work at least 500 hours for 3 years to be allowed to defer. The proposal is to reduce that from 3 years to 2 years. And then also there's for a 401k plan, an employer can't provide incentives, other than like a matching contribution in the plan for employees to encourage them to make deferrals under the plan. The new legislative proposals would allow employers to provide de minimis incentives like a gift card or some sort of incentives that are minor, but to encourage enrollment in deferrals and plans, which is often a challenge for employers to get employees enrolled and deferring and saving for retirement. Of these proposals, what do you think are the most interesting and exciting for clients?
Well, I think, because we all needed to pick me up as we make our way, past this COVID pandemic, I think Secure 2.0 absolutely does that. I was joking with my colleagues, there's a little bit of everything, something in here for everyone. So it's going to be, we've been talking to our clients about these potential changes. I hope we haven't oversold it, because I think what we likely will see, and maybe you'll agree or not agree, that we won't get all of the awesome things in Secure 2.0 that we want, but maybe, a few here, a few there over time. I'll say my clients are really, really excited about the additional age 60 catch-up contribution. Those organizations that have employees that do have the capability to save more. So that's really exciting. I would say far and away the thing that gets the most conversation, and really before Secure, is how do we help people, specifically our young people, save in a 401k plan or a 403b plan for that matter, where they have this exorbitant amount of student loans. So giving the employer the flexibility to either match the 401k deferral with their employer contribution or match the student loan repayment. It will be fascinating to see how many do kind of adopt that plan design. I know the record keepers are working on readying their systems for that, but it'll be an interesting integration process too. We've spent the last, 10 years talking about the merits of automatic enrollment and auto escalation. And I would say our clients far and away have adopted that when they can. It's going to be really neat to be able to tell the ones that haven't that, if you were a new startup plan, you would be mandated to put the automatic enrollment with the auto escalation, not just at 1%, but 3% and escalating all the way to 10. So I think that'll be a little bit of a wake-up call for folks that have not at least even considered, an automatic enrollment, auto escalation type design. We're getting to the period where, there's far and away only a few folks that have a defined benefit from a pension plan. And so this, in essence, turns your 401k plan into a defined benefit plan. Obviously, the difference being funded by the individual rather than the employer. But that's going to be neat and is neat for us to talk about with our clients.
Yeah, I think it's really important. It makes a lot of sense that the Secure Act and then the proposed Secure Act 2.0 recognizes the fact that we've moved from a defined benefit system to a defined contribution system. And so it's so important to get people participating in their 401k plan. The automatic enrollment achieves that. It's so important for younger workers to start deferring, because the asset that they have that those of us who may have been around a little bit longer don't have is time and the value of the earnings that accumulate over time. And so if someone isn't able to contribute financially because they're paying back student loans, if they're getting that matching contribution in the plan, there's savings occurring in those early years. So these things are really, it's recognizing the fact that we really are in a new type of retirement system that's based on, it's a defined contribution system based on employee savings.
Yeah, and it's neat too. I think if Secure 2.0 was to be passed in entirety, I think it's our legislators' way of saying we're giving you. We've heard the retirement plan community, obviously organizations like the American Retirement Association, who's lobbying for some of these things. It's as if they've heard for the first time that these are all the barriers. So, for example, the modernization of the tax credit. We've had that tax credit for individuals that are at certain income levels, tend to be lower income levels, but really not utilized because they're hard to understand or not meaningful. And the fact that we now will have a tax credit that's, a little bit more understandable, in terms of the maximum being $1,500. So it's almost as if they've heard from advisors and consultants and plan sponsors that, make it easy for our folks to understand. And that was really refreshing to see as part of this proposed legislation.
Well, that'll wrap up our discussion. Thank you, Nichole, for joining us on the Benefits Companion. If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.